The purpose of this talk is to provide a basic primer on Creative Commons licensing and expose some of the problems and solutions in using these licenses with geographic data and databases. So what's the problem? Well, the problem is copyright upon creation, whether you want it or not. So if you create an original doodle while I'm talking here, you have copyright in it instantly with no need to register your right, and regardless of whether most people would find instantaneous copyright to be reasonable. So if someone creates a story, song, image, or data set and places it openly on the web, is this free for me to copy without permission? So is it legal or not? Now keep in mind that not getting caught, or it's common practice, or there is small likelihood of getting sued in a particular instance is not the same as having a clear legal right to copy. So the lawyerly response to this question is, well, it depends. Now, in most instances, there is some minimal creativity in the work, and if so, the law assumes you must acquire permission from the copyright holder. Well, how can you know that there is or is not some minimal creativity in a posted geographic data set that would give it protection? Well, the fact is you can't know, the creator can't know, and as well, no lawyer can know. The only thing lawyers can do is provide you with their best professional opinion as to whether copyright applies in a particular instant or not. Right? So you can only know for certain when the gavel falls in a court of law on a case-by-case basis. So, without permission, you use the work of others at your peril. And as a result, most lawyers across the globe will tell you to always assume that a party will emerge to sue you if you don't acquire explicit permission. So, let's ask the following question. Are the effects of intellectual property laws on the internet different? And my short answer is yes. Okay, so let's first look at the paper world. Let's draw a box, and let's place inside this box all potential uses of creative works. Now, of course, we know that many uses are unregulated while others are regulated, and the regulation we're going to talk about here is copyright. Now, of course, we know that books are covered by copyright, but of course, after I buy that book, I take it home, I can read it as many times as I choose. Right? I can also take my CD home and play it. I can lend or give away these copies that I have purchased. As a matter of fact, I can take that book, I can give it to the library, and the library can continue to lend it over and over again many times. Okay? Now notice that none of these uses creates a new copy, and thus they are not regulated by copyright. All right? The law has also carved out uses that do involve copying, but says these fair use copies are legal. All right? So this limited copying might be for such things as teaching, research, criticism, scholarship, or news reporting. Further, you're free to extract from copyrighted works such things as facts, ideas, algorithms, and systems. Okay? So the law in the paper world has created a nuanced balance between the rights of creators to benefit from original work and the rights of new creators to build from those past contributions. All right? Technology, however, has very much shifted the balance. When we move to the internet, all of a sudden every use involves creating a copy. Therefore, there are no longer these exceptions for uses that do not involve copying. Further, fair uses and the right to extract such things as facts can be readily negated on the internet by requiring you to click a license before you are allowed to download data or software. All right. So we've thus moved from what we'll call a freedom to use culture where you didn't need permission for many users, and we've now moved to very much a permissions culture. So technology itself has very much altered the landscape. All right. In addition, laws across the globe are tightening. In the U.S., we have greatly increased the time lengths for copyright protection, and we've greatly increased the penalties for violations of copyright. And of course, to the typical citizen or legislative body, it only makes common sense that we should step up the battle against these digital thieves. All right, what about other nations? Well, in other nations, your ability to use digital works of others without permissions is even more restricted. So here in Australia, for instance, we have support of sweat of the brow. Depending upon the jurisdiction you're in, you might have additional laws relative to unfair competition, catalog rules, and database protection legislation. All right, and all of these extend well beyond the protections of traditional copyright law. So the bottom line is that we all tend to avoid the use of work products of others because we don't know their legal status. We have to assume that there may be a legal claimant lurking out there if we do some copying without permission. And it also turns out that asking permission is often too burdensome to bother with. So as a result, we have hundreds of millions of orphaned digital works. Now these are works that are not generating any economic income for creators, and in many instances creators actually place them out there on the web to be freely used, but we're afraid to use them because of the legal liability exposure. Now, of course, one of the alternatives is that we just choose to ignore the law, or we become lawbreakers whether we know it or not. All right, now you can respond that, hey, wait a second, that's not how it should be. Let's change the law. Let's go out and correct this situation by bringing the law back and correcting for this shift that technology has caused. Well, my response is, of course, good luck. We've already tried this in numerous instances, in numerous jurisdictions. We've been able to make very little headway. And in fact, as I said before, recent trends have actually been in the opposite direction. However, we can use the law, particularly contract law and technology, to create an electronic commons that we can all openly use. In other words, if you can't beat the law, let's join them and use the law proactively to solve the problem. So that brings us to Creative Commons licenses. So what's this all about? Well, with a few clicks in less than a minute, you can create ironclad licenses for any of your work to make that work readily available for the use of others. Now, Creative Commons licenses all have important features in common. All right? Every license will help you retain your copyright and announce that other people's fair use, fair first sale, and free expression rights are not affected by the license. Every license requires licensees, or in other words, users, to obtain your permission to do any of the things that you choose to restrict, to keep any copyright notice intact on all copies of your work, to link to your license from copies of the work. They agree not to alter the terms of the license, and they agree not to use technology to restrict other users' lawful uses of the work. Every license allows users, provided that they live up to your conditions, to copy the work, to distribute it, to display or perform it publicly, to make digital performances of that work, and they're allowed to shift the work into another format as a verbatim copy. Every license applies worldwide, lasts for the duration of the work's copyright, and is not revocable. Well, so what are some of the restrictions or provisions you might click to include in your particular copyright license? Well, the first obvious one is attribution. You let others copy, distribute, display, and perform your copyrighted work and any derivative works based upon it, but only if they give you credit the way that you request that that credit be given. Okay, another restriction, you might impose the non-commercial provision. So you let others copy, but for non-commercial purposes only. So if they want to use your work for a commercial purpose, they actually have to come back to you, ask for permission, and you, of course, can negotiate any price you want with them for their use of your work. You might impose the provision for non-derivative works. Here, what you're saying is you can go ahead and copy, but only verbatim copies of your work. For instance, you might not want them to alter your poem, for instance. There's also a provision called the share alike provision. Notice the C here, or the logo here, is a backward C. We sometimes refer to this as the copy left provision, or the GNU, or GPL provision, the general public license provision. And this is a viral provision whereby you allow others to distribute distributive works only under a license identical to the license that governs your work. So go ahead and build on my open access product, but if you do, your derivative product must also be an open access product governed by these same licensing provisions. And so that's about it. It's simple. It's rather straightforward. The technology behind all this is rather sophisticated. The legal reasoning behind all this is very sophisticated, but as far as the use go, it's very simple at the current time. So as of today, there are certainly well over 100 million licenses that have been created using this paradigm and have been linked back to the Creative Commons site. So if you go to a web browser like Google or Yahoo or any of the other major web browsers, you can now do a search and limit your search to open access products that are out there on the web, and then your search will result in hits only of those websites that have the embedded code for Creative Commons licensed works. Okay, now of course there are other specialty Creative Commons license options as well that have been created. There's something called the Founder's Copyright, which lasts for, you have complete copyright in your work, but you're saying you're only going to claim it for 14 years, and after that it goes into the public domain. 14 years, by the way, was the first copyright period limit for copyright in the United States. Something called the public domain dedication. We have a music sampling license, a music sharing license, a wiki license. So what about all those thousands of contributions to wikis? How can we ensure that they are openly accessible for other people to use? And then they also provide a version of the general public license. All right, is there a specialty license, by the way, for geographic data? But I'll get back to that shortly. Now, these licenses are not just for the web. You can also embed the Creative Commons licenses, the code for these licenses, in Word files, PDF files, and in the file formats for many other types of files. Okay. So let's ask the question, well, what if we wanted to create a Commons for Science? What Creative Commons license best fits the mores and traditions of science of the past several hundred years? Well, I would answer this question for creative works that the attribution license provides the greatest freedom for all of us as scientists to better be able to work from the scholarly advancements of each other. The currency of science, after all, is citations. As long as we get credit for our contributions, we're generally pretty happy. So if I were establishing an open access scholarly journal at the current time, what I would do is I would require all authors submitting articles to my journal to actually agree to an attribution-only license in that particular instance, because I think that is the license that has been proven over the past several hundred years, or best emulates the situation over the past couple hundred years, that has proven to be so valuable for science. But what about data sets and databases? Well, these actually turn out to be much more problematic. Many data sets are not creative works, and many databases are not actually copied, at least in the sense that we kind of extract information from databases in a kind of practical day-to-day operational environment. So I'm just going to raise a few points here. Now, facts are discovered, they're not created. We know then that facts are not covered by copyright. So then this raises the question, are empirical observations and measurements facts, and therefore not included within copyright? Are things like remote sensor outputs or property line measurements, are they actually facts under the law? Well, of course, much empirical data like this tends much more towards discovery rather than creation, and therefore many courts have held these types of dimensions to be non-copyrightable. All right. Now we know that, however, arrangements and selection of facts can be creative, but then again, many of the courts have come back, said, well, if it's a very standard arrangement, then it is not copyrightable. And of course, much of the time when we're talking about databases, we're trying to do very standardized arrangements of our tables in these databases to promote interoperability and efficiency, and therefore those types of arrangements are quite ordinary, and therefore that type of arrangement or selection is not copyrightable. And then even if you have a creative arrangement and selection, the way we actually use these arrangements in operational practice is not to copy an entire database, but to select specific fields from our databases or elements from the databases, and therefore we're creating our own new creative selection, coordination, and arrangement, and therefore again copyright many times would not apply in these instances. Now, Creative Commons licenses are meant to apply only to copies of creative works, and therefore as a general proposition we do not want to apply Creative Commons licenses to data and databases. Okay, we should not apply Creative Commons licenses to data and databases. Now, so therefore what do we do? Well, legal scholars have been struggling with what to recommend for now the past several years, and I think the best advice for the geographic data community at present is to use provisions adhering to the Science Commons Open Access Database Protocol. Okay, and this is a very recent protocol that's just been developed and is being recommended. So to ensure that your data can be used legally across the web for data mining, for web mapping services, and web feature services, I would highly recommend that you use something that's now, it's an instrument that's been developed to meet the Science Commons Protocol, and it's called CC0 with no rights reserved. Now, again, this is not a license. I've noticed that they've even avoided using the term of this being a dedication. But it's a way to waive all copyright and database rights to the extent that you may have those rights. Okay? So again, you may or may not have copyright, but if you happen to have copyright or you happen to have a database right in some jurisdiction of the world, this is a good way to waive those rights so that others are free to use the data set or database that you have made available through the web. And again, these scholars have tried to do this to cover the as many jurisdictions across the globe as possible. I should mention that this CC0 has not yet been announced, at least not announced generally, but some folks such as myself are already implementing the provisions in data repository environments to actually provide some examples of how this can be utilized once it is generally announced. So it's my belief that widespread use of Creative Commons Zero by the science community, by data producers across the globe within among those that really do want to share, should make web-based data mining and data integration much more legally defensible than it is today. So the work continues. I'd like to acknowledge the Creative Commons and Science Commons websites, as well as Lawrence Lessig's book on free culture, for some of the extensive graphics, text, and ideas used in this presentation.